Fourth case on this morning's docket, case number 119254 in the matter of John M. Knox. Counsel, before you proceed, I did want to ask a question after a statement this morning when the clerk of the Supreme Court spoke with lawyers. Mr. Knox did not appear for that orientation when the case was called around 9 o'clock for our docket call. Mr. Knox was not here. I'm going to ask again. I don't see anybody sitting at counsel table to indicate he is Mr. Knox or representing him, so let me make one last request. Is Mr. John M. Knox in the courtroom? I have received no acknowledgement. He is not here, so please proceed.
Okay. May it please the court, Stan Hazlitt appearing for the Disciplinary Administrator's Office. This is an original proceeding in attorney discipline. The first issue I would like to address is service on the respondent for today's proceeding. I learned from the clerk's office that the citation and the formal hearing report, final hearing report, were sent to the last registered address and the residence of the respondent. The certified was returned from both addresses unclaimed. The regular mail was not returned. The October docket, again to both addresses, I'm talking about his last registered address and his residential address. The regular mail was not returned. The certified mail was, there was a notation saying that there was a notice left at both addresses of the certified mailing. In the appearance docket, the regular mail was not returned from both addresses. And again, the certified mailing was, the postal authority said there was a notice left at the address. I should also inform the court that I sent Mr. Delaney, Bill Delaney from our office, the investigator from our office. The residence is in Overland Park, and Mr. Delaney attempted to personally serve the respondent with notice of the hearing today. Nobody came to the door, and Mr. Delaney left the notice in the door itself. Mr. Delaney has been there before and is confident that that is the respondent's address. So that's really kind of over and above the responsibility, but I just want to assure the court that I think that every effort has been made to let the respondent know about this hearing today. Just a really brief summary of the facts. The complainant, WD, was involved in a car accident, suffered serious injuries, was not his fault. He retained the respondent to represent him. Shortly after the accident occurred, a contingent fee was discussed, but it was never reduced to writing. The few times they did communicate, the respondent advised WD that everything was going okay. Communication eventually broke down completely, and a complaint was filed with our office. The respondent failed to cooperate with the investigation of the complaint, with the exception of one time Mr. Delaney went to see him to try to get the file, and to see the respondent to try to get the file, and the respondent did give Mr. Delaney the file, so we were able to turn the file back over to WD. Our investigator learned during the course of her investigation that the respondent actually filed 2 lawsuits. They were identical in Douglas County. Problem was they were filed 6 months after the statute of limitations had expired. I have no explanation for why 2 separate lawsuits were filed, but they were in fact both filed outside the statute of limitations. Both of those cases were dismissed. The defendant was represented by counsel. Both cases were dismissed. Our investigator had the sad duty and obligation to advise WD of this fact. That was the first time that the complainant understood that his cause of action was no longer existed because of the statute of limitations problem. And there was also evidence presented that the respondent did not have malpractice insurance. The rule violations were 1.1 competence, 1.3 diligence, 1.4 communication, 3.2 expediting litigation, 4.1 truthfulness in statements to others. And this occurred when the respondent told opposing counsel that the respondent had timely filed the lawsuit, but there was a glitch at the clerk's office that caused this problem. 8.4c, conduct involving dishonesty by assuring the complainant that the case was okay, that the complainant's case was okay. And 8.4D, prejudicial to the administration of justice for failing to timely file a lawsuit, failing to prosecute the case, and failing to respond to the defendant's motion to dismiss both of the cases. And finally, Supreme Court Rule 207, because of the respondent's failure to cooperate in the investigation. In this case, both our office and the panel recommend disbarment. The respondent has previously been disciplined by 3 informal admonitions in 2001, 2006, 2008. And on December 23rd of 2016, this court suspended the respondent for 1 year for violations of diligence, communication, fees, safekeeping of property, termination of representation, failure to cooperate in the investigation. The respondent never made an attempt to be reinstated. Part of the order of this court was that the respondent reimburse the Client Protection Fund, $3,000 that the Client Protection Fund had paid out to the victim in that case. That has not happened. That complaint was filed. This complaint that we're here for today was filed in March of 2016, so it was going on. We started investigating it while the process was going on in the previous case in which you suspended the respondent. There was one factor that I think really made a big impression on both our office and the panel itself, and the panel made a comment on it in its report. They commented on W.D., who was an elderly gentleman, his trusting nature, but he was an older gentleman on a fixed income, that he suffered obvious harm, and that this accident that was caused through no fault of his own, he was not able to realize the recovery of the damages that he clearly suffered. He had an operation because of some back problems after the accident, caused by the accident. He testified at the hearing that as a result of all this, he has $2,000 worth of unpaid bills, which he has to pay off at $20 a month. So the harm is obviously there and very tragic. So my recommendation as I stand here today, obviously, is still disbarment.
Do we have any questions? All right, thank you, counsel. The court will take this matter under advisement.